I'm Erin Daly, and on behalf of myself and Jimmy May, I'd like to welcome you to this segment of the Good Legal Stories series, a corollary to the Good Stories movement, sponsored by the Normandy Chair for Peace, an endeavor based in France with international participation, whose motto is, "We will have peace on earth when we have peace with the earth." To that end, the Good Legal Stories series spotlights landmark environmental cases from around the globe through the voices of those who worked on or decided those cases. Today, we are very excited that our good friend Melanie Murcott is with us today to tell us a good legal story about environmental justice and human rights in the context of farming for the future from South Africa. Jimmy, will you introduce us to Melanie?
Be happy to, Erin. Thank you. It's my pleasure to tell you more about Dr. Melanie Murcott. She's a senior lecturer in the Department of Public Law, Faculty of Law, University of Pretoria, where she teaches administrative law, environmental law, and other subjects. She holds an LLB from the University of Cape Town, an LLM from the University of Pretoria, and a Doctor of Laws from Northwest University. She's a leading legal theorist about transformative environmental constitutionalism and an advocate of her own right. Her research focuses on the potential of environmental law and administrative law to contribute toward especially South Africa's project of transformative constitutionalism. She's here to tell us about the Philippi Horticultural area case, a case that aims to advance human rights and environmental protection and farming for the future in South Africa. Welcome, Melanie, and tell us about this great legal story.
Thanks. It's wonderful to be here. So the Philippi Horticultural area case was brought by a group of subsistence farmers in the Western Cape of South Africa with a view to defending their farming activities for their communities. The area concerned involves around 3,000 subsistence farmers or small-scale farmers, and it indirectly employs a further 30,000 people and is a massive component of the Western Cape's provision of food, among other things. And the area has existed for a long time and has been farmed using horticulture for a long time, and is of huge importance to those who use it and enjoy it. And what happened was a major development was proposed by the city of Cape Town alongside the farming area. And the problem with this development is that it would encroach, as other developments have, on the farming activities, but also that it would threaten an aquifer, underground water resource for the farming activities. And so the farming community then took the city of Cape Town to court to try to stop this this development from taking place, with a view to preserving and sustaining their farming activities.
So thanks so much for that introduction. Can you tell us how the court dealt with the claims that were raised?
Sure. So what happened then in the court is that the lawyers brought, and this is very typical for South African environmental litigation, the lawyers for the farming community brought the challenge using the administrative law, arguing that the city's exercise of public power was not consistent with what was required of them by the law. And one of the things they did successfully, which is what makes this a good legal story, is that they said that the climate change impacts of the development, specifically with reference to water security, hadn't been properly considered, and that this rendered the decision to approve the development by the city of Cape Town and by the planning department in the Western Cape unlawful and contrary to South Africa's environmental law, as well as the land use planning laws that are in place. And that requirement to consider water security or water scarcity issues in a time of climate change isn't expressly written into the law. However, the courts read this requirement into the law, both as a duty for the city to consider and the planning department to consider. By virtue of South Africa's environmental rights, the right to an environment not harmful to health or well-being, and to have the environment protected for the benefit of present and future generations. And by using that right as an interpretive tool, the court was able to say that the duty to assess the impact on this aquifer in a time of climate change existed and hadn't been fulfilled. The duty hadn't been fulfilled, and therefore the conduct of the city and the planning department was contrary to the law.
So this is a really interesting example of claims that are really procedural in nature, doing a lot of substantive work to bring about environmental justice, human rights issues, and attention to climate change consequences.
Agreed. I think most of our South African environmental litigation is founded on procedural rights. What we have is a very wonderful procedural right to administrative justice, alongside a very wonderful right of access to information. The right to administrative justice says that everyone has the right to administrative actions or decision-making, including in the context of environmental governance, that is lawful, fair, and reasonable. And so in this case, the conduct was deemed not to be lawful, and the environmental right worked alongside the administrative justice right, as so as to inform what would be lawful conduct in the context of the environmental governance issues at stake.
And Melanie, you said the case invokes and involves the environmental rights provision of the South African Constitution. Could you tell us a little bit more about that provision in general and how it was impactful in this case?
Sure. So the provision was impactful. Well, let me say first what it's about. The environmental right in South Africa is a right that protects humans in the first instance. It hasn't been understood to protect environmental interests per se, but rather people's interest in and benefit from the environment. And so it's a human-centered right, but it is quite sweeping in its nature. So it recognizes intergenerational equity, rights for future generations, as well as intragenerational equity, so rights within generations. And it also imposes a duty to secure, or rather for the government to take measures to protect the right by securing ecologically sustainable development that promotes only justifiable economic and social development. And it's a wonderful right, but it hasn't in truth been unpacked a whole lot by our courts since 1996. And so it's getting old now for it still not to have an identity. But what we find is that it's used in a kind of intuitive sense to say, well, we have this right, it must mean something. So in this particular case, it was found to mean that water scarcity in a time of climate change must be factored into environmental governance decision-making. And so the court didn't really explain why exactly the right requires this water scarcity to be considered, or why climate change is such an important part of the environmental rights concern. But nonetheless, the court used this tool to interpret the statutory duties at issue. And I think the court could do a little bit more to unpack what the right means. The courts in general could do more. But I'll settle for this positive outcome with this indirect application of the right. The reason why we have these indirect applications of rights in South Africa is because there's a constitutional duty on courts to apply these rights or use these rights as an interpretive lens whenever they are engaged in statutory interpretation or interpretation of the common law. We have a powerful provision in section 39(2) of the Constitution that says courts must interpret the law with reference to the spirit, purport, and objects of the Constitution. And how that provision has been understood is that in environmental governance cases, the court must interpret the Constitution, or rather interpret the law with reference to section 24 of the Constitution. So we see these kind of oblique references rather than concrete explanations of what rights mean.
I'm very curious about what you said, sort of your whole notion of, that it has been interpreted. There's been lots of case law about Section 24, but it hasn't really developed an identity, a jurisprudential identity. And I'm just wondering what you would like to see as the environmental rights provisions identity within the constitutional framework of South Africa.
So I think I would like to see the court be more explicit about, for example, in Philippi Horticultural area, the court to say an environment not harmful to health or well-being as protected by the right is an environment where water scarcity is prevented. And so to make those links very explicitly. We have an ongoing case referred to as the deadly air case currently in South Africa. And there, what I would like the court to say is that an environment not harmful to health or well-being is an environment that doesn't see thousands of people in South Africa die every year from toxic air pollution. So to link the claim and the reasoning around the claim to the content of the right in a much clearer and more direct way, so that in future cases we can say, well, this is the very minimum what a reasonable measure to advance this right is. It's not one that takes away water security and food security. That isn't what the right has in mind. A reasonable measure to advance the environmental right would be one that doesn't see thousands of people die every year, or that doesn't result in water scarcity for thousands of people, for example, in these cases.
Melanie, so many of our stories are, involve, thousands of people, like you just mentioned in this case, can potentially involve as well. But they're also personal stories. What is it about this case, this story, that speaks to you as an advocate, as a leading scholar, and as a legal educator?
What I really loved about this story is that it's a story about agency for this community and self-determination. And it's also a story about a community that has chosen not to subscribe to the dominant neoliberal capitalist way of living, and is trying to do something regenerative and forward-looking, and that community's interest and concern for its environment was recognized and protected. And what we've seen since then is that the Department of Agriculture in the Western Cape, which developed a plan for the protection of this area, recognizing its significance, has said that the plan must happen. And so that sort of reinforces the importance of this area and the importance of this community. For me, it's a story about the idea of justice as recognition of those who are not always given a seat at the table. And the litigation, in a way, gave this community a seat at the table and amplified their voice and their concern. And the Western Cape Department of Agriculture has reinforced that through a subsequent statement. So it says, The area is an urban asset that contributes to the city of Cape Town's water resilience, inclusivity, food security, and sustainability. And for that reason, it must be protected. And I think that that's what makes this such a good legal story about the protection of the environment.
Well, that's such an inspirational story as well. It starts off as affecting a few people in a community and then more people in the community, and then is used as a means to transform constitutionalism in South Africa, which then serves to reverberate throughout the globe, given the prominence of that provision in environmental constitutionalism in particular. Melanie, thank you so much for telling that story. Another wonderful story. And that concludes this segment of the Good Legal Stories series, everyone. Thank you so much for joining us. So long. See you next time.